being charged with a crime's scary, right? Especially for somebody who's never been through it. They're innocent. They don't know what's going on. And, most people in that scenario get a lawyer very early on, which is exactly the right thing to do. But the first court date, after kind of that initial, first appearance, preliminary hearing, bond hearing, all that stuff, the first court date after a case is indicted is going to be your arraignment, right? And arraignment is really just a time, practically, for the court to make sure you know what you're charged with if you don't know, and to pretty much make sure you have a lawyer. So in almost all of our cases, we waive arraignment, which just means we're not going to go. Because if you have a formal arraignment, the judge is just going to read the charges against you in open court, right? Whether they're true or not, he's just going to read out loud what you've been charged with, whether it's marijuana, sexual assault, murder, whatever it may be. He's just going to read it in the courtroom. Be like, you understand what you're charged with? And you're going to say, no, I didn't freaking do that. I don't understand. He's going to say, no. I'm not asking you whether you did it. I'm just asking if you understand what the prosecutors say you did, right? So there's very little reason for us to do that because we can read the indictment and tell. So we typically waive that arraignment. And basically all that happens is the judge is going to issue new court dates, usually some combination of a calendar call or a motions date or a trial calendar, so that we can get the case moving. So it's common to waive arraignment. We do it in almost all of our cases unless there's some special circumstance, and that's what happens. You get a new court date, basically, and then the case gets moving.